Good afternoon, everyone, and thank you for joining today's webinar on how to navigate and prepare for the changes to consumer laws and enforcement introduced by the Digital Markets Competition and Consumers Act. I'm Christopher Hutton, a partner in our competition team and group manager of our global regulatory practice here in the UK. The DMCC introduces significant changes to the consumer law landscape, and so we have a lot of ground to cover today. Jennifer Crust, a senior associate in our strategic operations agreements and regulation team, with Alice Russon, an associate in Jennifer's team, will begin by taking us through some of the changes to the law. Michaela Bostrom, an associate in our SOAR team, will then outline the new enforcement regime and what that means for businesses. As the new regime is modelled on the competition law enforcement regime, Jamie Pollock, a senior associate in our competition team, will provide insights as to how we expect the new regime to work. I will then consider the extent to which we can predict the areas where the CMA will prioritise its initial enforcement. And finally, Jenny will take us through some practical tips on the steps businesses should be taking now to prepare for the new regime. And with that, I will hand over to Jenny.
Great, thank you, Chris. So for those of you that aren't aware, the DMCC Act, among other things, seeks to regulate the practices traders adopt when dealing with UK consumers. It does this by prohibiting a series of practices which it considers unfair and by requiring traders to act in a certain manner. The Act essentially restates and updates the existing regime. Now, we haven't gone through the structure of the regime in detail, partially on time and partially on the assumption that we're assuming most of you are familiar with it. But if you're not, do reach out afterwards and we'd be really happy to provide that detail. So before we get into the key changes, we want to take a moment to explain the reason behind the updates to the existing regime. The first of these is that existing legislation is over a decade old. The Consumer Protection from Unfair Trading regulations came into force in 2008. And whilst there have been a few updates, they didn't really bring the legislation in line with how traders operate in today's market, which is increasingly digital. A good example of this is that subscriptions are now relatively widespread, but the existing regime contains no specific rules on how these should be offered to consumers. The second key reason is that within the government and the Competition and Markets Authority, who's the primary regulator in this space, there's an impression that compliance with consumer protection law just isn't taken seriously. Now, that in part is because the risk of day-to-day infringements resulting from enforcement action are low. And actually, for the vast majority, I suspect you're more familiar with the industry regulator, so the Advertising Standards Agency. So the lack of enforcement risk has meant that companies are often willing to run the risk of risky practices. So the changes here are looking to address much needed updates and also place consumer compliance as a board level issue. And if we could just flick through to the next slide and then one more. Thank you very much. So what are the key changes? And just a quick note here that as I run through these, whilst I do refer to products, these rules actually also apply to services. So the first key point to make is that the existing rules are largely maintained and restated under the DMCC Act. But as mentioned, there are some notable updates. The first of these is that where material information, so these are things such as price or the key product characteristics, are omitted from an invitation to purchase, that is now an automatical infringement and automatically unfair. So under the existing regime, what would have also needed to be shown is that the omission of this information meant that the consumer took a different transactional decision. That's no longer the case. So that makes enforcement in this space much easier. Now, a brief explanation on what an invitation to purchase actually is, as it feels a relatively antiquated term. But essentially, it's anything that communicates to a consumer the price and characteristics of a product or service. And that then enables them to decide whether or not to purchase that product or take another transactional decision in relation to that product. So in the same vein, if we go across to the next slide, another notable change is that in terms of what material information needs to be shown on an invitation to purchase, the rules have now been updated to set out some specific provisions relating to drip pricing. Now, that's the practice of where the price advertised for a product at the start of the consumer's journey increases as the consumer moves through the process on account of certain unavoidable charges. So that would be booking fees is the usual example. Now, this is something already captured in existing legislation, and it is an area that the CMA has taken enforcement action on previously, but the practice does remain widespread. So the changes here are to ensure there are clearer obligations on how pricing should be displayed to consumers. The key change is that the headline price displayed to consumers on an invitation to purchase must now be inclusive of charges the consumer will have to pay to use or purchase the product. So these prices can no longer be displayed separately. So taking a concert ticket example, which is one of the CMA's favourite areas in this context, if tickets were £100 and booking fees were £10, the headline price that should be shown to consumers should be £110. The Act also requires that the headline price reflects the life of the contract. So interestingly, this would mean if there was a 6-month fixed contract for gym membership and the cost of that is £10 a month, the headline price displayed should actually be £60, which feels a relatively new concept. Now, the Act does accept that in all cases, being able to display the final price up front is not going to be possible. And that could be because a product's price is determined by specific weight or select features. And where that is the case, the requirement is instead that traders display as prominently as the headline price how the final price will be calculated. The key point that always comes to everyone's mind here is how do we deal with delivery charges? Because these are charges that actually, in the vast majority of cases, are mandatory. They will need to be paid in order for the consumer to get the product, but they tend to vary depending on the method the customer chooses. Now, there has been draft guidance issued by the CMA on some of the changes to the DMCC, some of the changes to the existing regime, and they do pick up this. Personally, it would be nice if they had a few more examples, but what they're suggesting is that where the consumer could genuinely opt for delivery in a certain way, so to collect a product or for express delivery, this information can be displayed separately to the headline price, provided it's in close proximity, and where space is an issue, it's viewable following minimal action by the consumer. So the example in the draft guidance was to refer to a learn more link. What the draft guidance does say is that that information at the bottom of a web page, for example, wouldn't be acceptable. So hopefully there'll be a bit more clarity on this when we get the next iteration of the guidance, but it's certainly worth noting now that the way you display prices to consumers is changing. The next key change is the use of fake reviews. Or the publication of fake reviews in a misleading way. So that has now been added to the list of practices that are automatically deemed unfair. Now, a fake review is anything which is not based on a genuine experience. It could be positive, it could be negative, and it's either because it's entirely fake or because it conceals that it's been incentivized. Now, again, on timing, and there are much more interesting changes to take you through to subscription and enforcement. I'm not going to delve too much into this, particularly as the use of fake reviews and publishing reviews in a misleading way is actually something I hope none of you are already doing, because it's already prohibited under existing legislation on account of it being misleading. But one really important change in this space is that the DMCC Act now places on traders a positive obligation to take reasonable and proportionate steps to prevent the use of fake reviews, either by not publishing them or removing them from publication. Again, the draft guidance has been really helpful here that was issued just before Christmas. And this suggests that it's unlikely there's going to be a one-size-fits-all approach in terms to compliance with this positive obligation. But the expectation is that traders will have a policy to deal with fake reviews and essentially also conduct regular risk assessments on the presence of fake reviews within its practices. So that's something we don't generally see clients have as at today's date. And it's certainly something that's now going to be developed ahead of April. So one to pay attention to. Relatively whistle-stop tour of those changes, but I will hand you over to Alice, who will go into a little more detail on the changes to subscriptions.
Thanks, Jenny. Next slide, please. So as Jenny just mentioned, another area that's directly affected by the DMCC is subscription contracts. And it's particularly key for businesses to be aware of the changes in this area specifically, given we had such minimal regulation previously. In fact, all we really had was some guidance published by the CMA, which didn't have legislative force. Therefore, it's pretty likely that all businesses that interact with subscription contracts are likely to need to make changes to achieve compliance. The DMCC itself sets out the broad framework for regulating these contracts, but actually quite a few aspects of the regime will be implemented by secondary legislation. And right now, the government is currently running a consultation addressing the content of that secondary legislation, as well as the guidance that will sit alongside it. So during this portion of the webinar, we'll talk about the relevant provisions of the DMCC itself, but also the suggestions the government has made in that consultation. One point to note at the outset, which is quite interesting in this respect, is that the consultation really shows the government are keen for the CMA to take a practical and pragmatic approach rather than simply focusing on the black letter of the law. And that really shows the government are keen to show they're taking a business-focused approach in this area. In terms of timing for compliance, the provisions of the DMCC which address subscription contracts aren't expected to come into force until spring 2026 at the earliest. So there is quite a bit of time to prepare. And we expect the government intend for the accompanying secondary legislation to come into force at the same time. However, the consultation I mentioned actually closes on the 10th of February, so in 5 days' time. Therefore, if you do want to respond to that consultation, now is very much the time to do so. Another key point to touch on initially is exactly which contracts are subject to these rules. So the definition of subscription contracts does extend to all contracts we would typically expect to be classed as a subscription. So a contract which auto renews and the consumer needs to actively take steps to end it rather than it expiring on its own terms. However, there is another category of contracts which are captured, which you may not necessarily think of as subscription contracts. So these are those which begin with a free or reduced price period, followed by an automatic continuation onto a higher price contract if you don't cancel. So using an example to illustrate this, if there was a 6-month gym membership which had a 2-month free trial and you could cancel after that free trial if you wanted to, but if you don't cancel, it rolls on to a 4-month contract at the normal membership rate, that would be classed as a subscription contract for these purposes. Another really key point to flag in this area is that there are a large number of excluded contracts. So these contracts aren't subject to these rules at all. And that's usually because they're regulated separately under a different regime. It's quite a long list, but it includes utilities contract, insurance and financial services contract, and rental of residential accommodation, amongst others. Last point on this topic, it's also worth flagging that in-person subscription contracts are captured too, so it's not just those which are entered into online. Next slide, please. The DMCC provisions on subscription contracts are quite detailed and complex, but broadly speaking, we can split them into 3 categories, which are shown on the slide. So the first of these is the rules surrounding cooling off periods. The second are the requirements addressing consumer cancellation. And then lastly, information requirements, which are specific to subscription contracts. And I'll briefly discuss the most significant change from each of these areas in turn. So starting with cooling off periods, quite a significant proportion of the consultation talks about the rules surrounding cooling off periods. And it seems that this will be the most complex area, which will be established by secondary legislation. The consultation follows the approach taken under existing consumer protection laws. So the general principle is a consumer can cancel for free during the cooling off period when they enter into a contract. However, the really key change we have in this area is that we now also have renewal cooling off periods. So these will be triggered when a consumer is liable for certain renewal payments. So the practical effect of this is that customers interacting with subscription contracts will have quite a few more chances to exit the contract for free than they do currently. This area of the consultation is one of those which shows the government attempting to take a business-focused approach. And overall, it is our view the proposals they've made are quite sensible. For instance, the government has stressed that they understand services and digital content, once they've been delivered, can't be returned, and a consumer shouldn't be able to receive services and digital content for free and then return it for a full refund. So for instance, if you binge watch a load of streaming content and then return for a free refund, that shouldn't be possible under the new rules. And secondly, the government's also stressed that certain rules shouldn't apply in renewal cooling off periods, because in reality, this would just lead to an interruption of supply, leading to inconvenience for consumers and then many complaints and administration costs for businesses. Moving on to consumer cancellation, the headline point under the DMCC on this topic is that businesses must ensure there's a straightforward method by which a consumer can exit their contract. So for instance, if you entered into a contract online, you should be able to exit online. The government have confirmed they're going to publish guidance on how exactly to comply with this requirement, because the wording we've got at the moment is pretty vague. So once that guidance is published, we'll have a bit more detail on this point. And at that stage, it should be when businesses really start to audit the cancellation mechanisms they currently have in place and assess to what extent these actually align with the government's expectations in this area. And lastly, moving on to information requirements specific to subscription contracts, there are quite a few new rules in this area. but one of the most significant of these is the new requirement to provide reminder notices. So these are given at certain key points in the life cycle of a subscription contract, such as ahead of a certain renewal payments or if the customer decides to cancel their contract. The government is going to prescribe in secondary legislation exactly how you give these notices. However, at this stage, it's really worth businesses starting to think about the operational changes that will be needed to comply with this requirement. For instance, it's likely for many businesses, there'll need to be changes to the programming of IT infrastructure so that reminder notices are sent automatically to customers when required for that specific customer. And it's likely that this is going to be quite a complex task for many businesses. So even though the rules don't come into force until spring 2026, which is quite a way away, it's well worth monitoring the updates in this area at this time and starting to plan operationally for how to achieve compliance when those new rules do come into force. So that's a high-level overview of the subscription contracts provisions. And now I'll hand over to Michaela, who will explain the consequences of failing to comply with these new requirements.
Thank you, Alice. So yes, I'm going to talk about some of the key aspects of the new enforcement framework created by the DMCC Act, which is expected to take effect from April this year. Next slide, please. So the DMCC Act provides for two regimes for the enforcement of consumer protection law. There's the direct enforcement regime, which is civil, and the court-based enforcement regime, which may be civil or criminal. And the direct enforcement regime is entirely new, and it allows the CMA to take enforcement action directly in case of infringement of certain consumer protection laws. So before the DMCC Act, the CMA had to apply to court for an enforcement order if it suspected an infringement, but the CMA will now be able to take action without going to court. And from the DMCC Act commencement date, the CMA will have a range of new powers. The key one being that the CMA will be able to issue civil penalties directly on infringing companies, which can be up to the higher of £300,000 or 10% of global turnover. So this marks a significant increase in the CMA's powers compared to what we've seen before. And while there are other enforcement authorities that can also enforce consumer law, which I'll come on to in a minute, they have to use the court-based process. The CMA will be the only enforcement authority that can make its own decisions on breaches of certain consumer laws. So in parallel with the direct enforcement regime, there's still going to be a court-based process. So the CMA will still have the ability to apply to court for an order in case of certain consumer law breaches. And the new court-based regime largely mirrors the old one, save for some significant differences. The key one being that the courts will now have the power to impose civil penalties for a breach of the law, which it was not able to do before. And the cap is the same as under the direct process, so the higher of £300,000 or 10% of global turnover. And in addition to the civil route, the CMA has the power to prosecute traders criminally in respect of some consumer law breaches. And this applies in particular to most unfair commercial practices. That being said, many consumer law breaches are not criminal offences. So breaches that are not criminal include, for example, the inclusion of unfair terms in consumer contracts, a failure to provide pre-contract information, and with one exception, breaches of the new subscription contract requirements, which Alice just outlined. And that means that prosecution is not an option for those breaches. Next slide, please. Next slide, please. Thank you. So a few key points on the enforcement. Other than the CMA, a number of other enforcers will also be able to apply to court for an order, and that includes trading standards and some sectoral regulators such as the Financial Conduct Authority and Ofcom. And alongside the CMA, trading standards also have the power to prosecute traders criminally. However, these other enforcers will usually be required to obtain the CMA's consent before they make an application to court, which underlines the fact that the CMA is the primary consumer law enforcer under the DMCC Act. That being said, both the CMA and trading standards are responsible for consumer law enforcement. And in terms of how they split this responsibility, the focus of the CMA is on market-wide issues, while trading standards tackles consumer detriment more generally. So, for example, where an infringement involves a single business, unless there are additional factors which makes it suitable for the CMA to handle that case, for example, because the CMA sees an opportunity to change the practice of a market as a whole, it will usually be appropriate for trading standards to handle it. And generally, the CMA has said that it will use its direct enforcement powers if it decides to pursue a consumer law infringement. However, the CMA might still use the court-based process in some circumstances. So, for example, the CMA might go to court if it thinks that a practice should be prevented urgently, and this requires the assistance of the court, or if it considers it to be in the public interest to pursue a criminal prosecution. So this might be where the breach is deemed to be very serious. For example, a practice that is deliberately misleading and causes significant consumer detriment. And because of this, the CMA considers prosecution to be justifiable to protect the public. So just to summarize what is arguably the key changes brought about by the DMCC Act. The DMCC Act introduces civil penalties and direct CMA enforcement powers. So before the DMCC Act, there were no civil penalties for breaches of consumer law. A fine could only be imposed if either a court made an order and then that order was breached, or if something was a criminal offense and then prosecuted. But as I mentioned, many consumer law breaches are not criminal offenses. There's also a higher standard and burden of proof to pursue criminal prosecution, and it has to be shown that prosecution is in the public interest. So for these reasons, the risk of penalties before the DMCC Act was much lower than it's going to be going forward. Now, the hurdles for a penalty to be imposed have been significantly simplified, and at least in principle, almost any breach could lead to a financial penalty as long as it's within scope of the DMCC Act. Next slide, please. So I mentioned what the maximum cap is, and I'll shortly get on to some of the factors that we've taken into account to calculate the penalty. But first, I'll just briefly explain what type of infringement is in scope of the Act. So in either case, whether it's under the court-based enforcement regime or the direct enforcement regime, action can only be taken in respect of a relevant infringement. And that is one which harms the collective interests of consumers. And that essentially means a section of the public who are consumers. And case law on this concept has found that harm can be inferred from the accumulation of individual instances of harm. And that essentially just means that consumers, there can be several consumers who are completely unrelated to each other, but because they experience the same type of harm, that is sufficient for the harm to be harming the collective interest of consumers. Then there has to be sufficient UK connection. And that's satisfied where the trader has a place of business in the UK, carries on business in the UK, or if the commercial practice occurs as part of activities that are directed at UK consumers. Finally, there has to be a breach of one of the pieces of legislation specified in the Act. This includes essentially all the key consumer law enactments. So, for example, it includes all the rights and remedies and requirements for contract terms to be fair under the Consumer Rights Act. It includes everything relating to unfair commercial practices and subscription contracts under the DMCC Act, and it includes all regulations under the Consumer Contracts Regulations. So that's the one that sets out pre-contract information requirements and cancellation rights. Next slide, please. So just to briefly explain the factors the CMA will take into account when determining the amount of any penalty. And this is based on the draft guidance published by the CMA last year. So as I mentioned, the CMA may impose penalties capped at 300,000 or if higher, 10% of a party's global turnover. And this includes turnover of any person that controls the infringing company or and any person that company controls. But because the CMA is focused on harm to UK consumers, the starting point will generally be 30% of UK turnover. And that is for a breach that is considered serious, so where there has been major harm to consumers and high culpability. After that, the CMA can adjust the penalty to ensure it's sufficient to deter both the infringing party and also others in the market from committing similar breaches, and also to take account of the size of the party and its financial position. So the penalty might be increased for a large company, for example. Third, the penalty might be increased in case of aggravating factors or decreased in case of mitigating factors. An example of an aggravating factor would be continuing the infringement after having received a warning by an enforcer. An example of a mitigating factor would be fully cooperating with the CMA. And as a fourth step, the CMA will then consider the penalty to make sure it's proportionate given all the relevant circumstances. And this is also where the CMA will check to make sure the maximum cap of 10% of global turnover is not exceeded. And finally, if a company has settled with the CMA, which includes admitting to the infringement and ceasing the infringing practice, the CMA may apply a settlement discount of up to 40%.
And I think it's just worth coming in there on that maximum 10% of global turnover cap, which is quite a sort of scary looking cap. That doesn't mean that the fines are going to be that high, but it does mean that it kind of affords the CMA quite a high degree of flexibility in terms of how it goes about deciding on its penalty. So in the context of the CMA's competition regime, we have seen a very broad spectrum of CMA fines ranging from, on the one hand, the low 1,000s up to sort of mega fines for abusive dominance behaviours, which can run up to the order of hundreds of millions of pounds. And I think, as Michaela sort of suggested, there are a range of different factors which the CMA would consider when setting the fine. But kind of key to all of this is the duration of the bad behaviour and how the business has dealt with learning about what's gone wrong, which kind of obviously the experience of learning can bring the infringement to a close. So if you were aware of a potential issue and did nothing about it, then it's likely to lead to an increased fine. And in any case, establishing that there's been an infringement of consumer law as soon as possible is going to be really important in terms of customers seeking redress and the business responding in order to deliver that redress to customers. So the key message in all of this is to kind of get on top of this as soon as it's possible and the business becomes aware of it, because that could have a material impact on the extent of the fine.
Thanks, Jamie. And two further quick points to note on penalties. One is just that the CMA could also impose penalties in some other cases. So, for example, for breaches of undertakings and directions given by the CMA, or if false or misleading information has been provided to the CMA. And it's also important to note that there is a possibility to appeal the decision to impose a penalty or the amount of the penalty. Next slide, please. So just briefly on transitional provisions. So from when might infringing conduct attract penalties? The old law on enforcement, which is still the current law until April this year, under which civil monetary penalties are not available, that will continue to apply and be the appropriate procedure for any enforcement action in respect of conduct taking place before the commencement date, which does not continue past that date. However, where there is continuing conduct, and that means conduct taking place before the commencement date, which then continues or is repeated after the commencement date, in that case, the new law applies to all of that conduct. That being said, this is subject to one very important limitation, and that is that any requirement imposed by the CMA or the court in respect of the pre-DMCC Act conduct, that can only be imposed to the extent that it could have been imposed under the old law. So this means that the CMA and the court can only impose a civil penalty where infringing conduct takes place after the commencement date. So it follows that if something is a relevant breach today, but the infringing practice ends before the DMCC Act enters into effect, then no civil penalty can be imposed by the court or the CMA. However, the CMA will still be able to take direct enforcement action in respect of that continuing conduct, and an infringement finding by the CMA would still increase the risk that consumers could bring a claim, which might include a claim for collective redress. So this does mean that just because civil penalties will only be available for conduct occurring after the commencement date, this doesn't necessarily rule out the possibility of financial consequences. Next slide, please. So just briefly on what the CMA has said on when it might accept an undertaking. So sometimes when the CMA considers there to be a consumer law infringement, it might accept an undertaking instead of continuing its investigation. And an undertaking is a voluntary commitment from a person relating to their conduct. So for example, not to repeat or continue the conduct of concern. But an undertaking does not require any admission that there's been an infringement or the payment of any penalty. And either party can propose an undertaking during a CMA investigation, but the CMA has broad discretion determining whether to accept an undertaking in a particular case. And the new draft guidance published by the CMA sets out some interesting points on when the CMA is more or less likely to accept an undertaking. So in particular, the CMA is more likely to accept an undertaking where it adequately addresses the CMA's concerns and can be implemented efficiently and quickly. In contrast, the CMA will not accept undertakings where it considers that compliance with an undertaking would be difficult to monitor, or where not completing the investigation and making a decision on infringement would undermine deterrence. And finally, the CMA said that it's unlikely to accept an undertaking if there's been a previous failure to comply with an undertaking by that business.
And again, I think it's just worth noting that undertakings and commitments are fairly rare on the competition side, but they could be less so in this consumer context if the CMA can be convinced that they'll provide full redress to consumers, so resolving the issues that have been identified. And if it's possible to achieve that closure through undertakings, then this is generally a good idea both for the CMA and the business. And that's because it really shouldn't be underestimated just how intensive and potentially very expensive going through a CMA investigation can be. It takes up a lot of external resource, so lawyers and other advisors, and also the sort of internal resource of the business, which can include the management time of people at all different levels of the business. So I think as a sort of practical thought here, if there is an option to agree undertakings, which could cut the investigation short by, for example, delivering redress to customers, then it's definitely worth considering agreeing to those in order to sort of make that happen.
And with that, we will hand over to Chris, who will talk about what we expect the CMA's priorities to be once the new enforcement powers enter into effect.
Thank you very much. Next slide, please. So this is where we get at our crystal ball and see whether we can see anything that helps us understand which areas the CMA intends to focus on. What we can say with some certainty is that we will see an upswing in the CMA's consumer law enforcement. There's a very basic point, which is having requested these direct enforcement powers, the CMA really will have to be seen to be using them, otherwise it may risk losing them. And in fact, the new regime is very explicitly intended to make enforcement easier on the part of the CMA, but also, as we've mentioned before, part of the regime is also there to drive compliance through deterrence. All of that said, we are expecting this upswing, but the CMA should expect some significant challenge in relation to some of the first cases. That's certainly what we saw in the competition regime, and that will obviously depend on the nature of those cases brought. But the CMA may be slow at first to bring some complicated or potentially controversial cases. The CMA also has limited resources, and actually increasingly limited resources. You may have seen that the CMA has announced a 10% headcount reduction over the past couple of weeks. That headcount reduction won't actually affect some of the CMA's enforcement powers, so it won't affect their merger control powers or their digital markets unit, which means that areas like consumer enforcement may be disproportionately impacted by that cut. So again, it remains to be seen whether the work that CMA has been doing to ramp up enforcement here will actually be curtailed by that announcement. And also the CMA will have to decide which powers to use. And as we've already discussed, sometimes these consumer powers may not be the most appropriate powers. So obviously the CMA has its digital markets powers, and there is potential overlap there depending on how depending on the nature of the codes of conduct that the CMA introduces there, but also lots of these consumer-related issues could also fall within the markets review regimes. And again, what we expect the CMA to do over this is to decide which areas it can enforce more easily, and often that should be the new consumer regime. Next slide, please. So the CMA has given us some guidance as to when it will consider consumer law enforcement to be appropriate. We've touched on some of these already. The first is where breaches of the law point to systemic failures in a market. So again, not necessarily just relating to one individual company, but is there an issue across the entirety of a market or a sector? And so where changing the behavior of one business could actually have market-wide implications or sector-wide implications. There's also the precedent-setting value. The CMA hasn't had much opportunity to set precedents in consumer law under the old regime, and where it has, it's not always had the greatest success. So we do expect the CMA to try and push the boundaries using this new regime in order to set legal precedents. And as we've already discussed, and we'll come on to a little bit more detail later, the CMA considers that there is a deterrence factor in place, and this regime is intended to promote deterrence, and it will consider that as part of where it should take action. Next slide, please. But the CMA also has separate prioritization principles, which applies across all of its functions. I'm going to focus on 2 of those today, but all 5 of the key factors the CMA takes into account are listed on the slide there. But we're going to focus on strategic significance and impact, and obviously those 2 things are intertwined. In terms of what is strategic significance, the CMA's annual plan gives us some insight as to what the CMA considers to be strategically significant. And that is its ambitions for people to be confident that they're getting great choices and fair deals, that competitive and fair dealing businesses are able to innovate and thrive. And this is a point, again, we'll come on to later in terms of how the CMA may initiate these cases. But also that the whole of the UK economy is able to grow productively and sustainably. Now, those 3 principles are obviously very broad, and they're intended to be. So the CMA has a huge amount of discretion over its own prioritization across all of its functions, and we certainly expect to see that in the consumer sphere. Next slide, please. But we also have some insights into the specific sectors and areas that the CMA may want to focus on. So in its current draft annual plan, which is open for comments, the CMA has stated that one of its priorities is to protect consumers from misleading or high-pressure online sales and pricing practices. We've already seen that in some of its publications and actions so far. Also wants to focus on the areas of essential spend. Again, that focus on the consumer, and we've seen outside of the consumer area, the CMA looking very closely at retail prices, etc. And again, we expect that to develop with this new regime. But also the CMA in the draft annual plan says it will have a focus on drip and dynamic pricing, travel and housing sectors, and also online entertainment. The CMA has also said that it will look to the results of the CMA Consumer Detriment Survey, which are due to be published later in 2025, and that the CMA has stated that lots of its actions will be informed by the results of that survey. In theory, that sounds like a good idea, and the 2022 results do give an area of possible focus, assuming that customers still have the same thoughts and feelings about some of these sectors. And as you'll see from the bar chart there are a huge number of, this is just the top 10, but a very broad range of sectors involved, including airline, package holidays, vehicles, internet provision, etc. What I would say, though, is that if you look down that list, you can't see a huge amount of CMA enforcement over the past 3 years in relation to those sectors. So it will remain to be seen the extent to which the CMA slavishly follows the Consumer Detriment Survey, or whether it's just a factor that the CMA may take into account when it's making its prioritisation decisions. But I do think that it is worth looking very closely at the results of that survey and the extent to which it applies to your particular sector. Next slide, please. So here we turn to the second of the CMA's key prioritisation principles, and that is impact. And here we're looking at the direct and indirect impact. In terms of direct impact, that's usually very clear. The CMA is very focused on the financial impact of its enforcement action and the benefit to consumers. The CMA often, when it takes action, releases a press release to say that this will save consumers X million pounds at the end of every year, and certainly in its annual reports. The CMA is always very keen to state that its action has saved consumers or the UK economy X million billion pounds. So we should expect the CMA to focus very much on that direct impact. But as we've discussed, the indirect impact of its action also weighs heavily on the CMA, and again, we should expect that certainly in the early stages of the enforcement regime to play a significant role. So obviously we have the deterrence impact, and here I don't think we can really emphasize this enough, because when we attended a DBT roundtable, it was very clear from government that there was a strong perception that businesses don't take consumer law compliance seriously, and that this new regime was in part intended to drive compliance by putting it at the top of companies and boards' agendas. And again, we have a very similar statement from the CMA in its draft annual plan, where the CMA says that companies should regard competition law and consumer protection law as having equivalent footing, and that businesses should regard them with equal importance. So again, that really goes to the fact that the CMA and in fact the government intend this regime to have a strong deterrence effect. Now, obviously, that may go to the way that the CMA investigates and also the level of the penalties. But also it will go to, as we'll come on to in a moment, the enforcement mix. But the last point on indirect impact is also, as we've also discussed, the wider impact on business and consumer behaviour. So that, again, we may see the CMA taking action where it thinks actually taking investigation in relation to one entity or one sector will have wider implications across others. So what will be particularly interesting to see at the start of the regime is the enforcement mix. And from experience, we do expect that enforcement mix to be designed to have the maximum impact, with a particular focus on early, quick and impactful wins. So what we are very likely to see are some very high profile names in the initial enforcement round. That said, we will also expect the CMA to want to set some very early precedents, and it may be concerned that going after some high profile names may result in those precedents being delayed because they're more likely to face a significant challenge. So we may then see the CMA bringing also some cases against smaller companies who are less likely to challenge the CMA in order to, if you like, get the CMA's precedent bank up and running. Similarly, we're also likely to see the CMA focus on some easier cases, which will have some significant cross-sector precedent value. Next slide, please. One very important issue, though, around what the CMA's enforcement is likely to be over this initial stages is where are the cases going to come from? Historically, the CMA has very heavily focused on customer complaints. For example, during the COVID pandemic, the CMA was very open about the fact that the number of complaints was literally the primary driver of its prioritization principles. Over time, the CMA has also developed its intelligence gathering, and it has said that it's going to devote more resources to that, including not just the substandard intelligence gathering, but also potentially secret shoppers, in order to gain evidence and decide whether it should be taking action. The CMA is, in theory, an independent, apolitical body, but as we've seen over the past few weeks, that is slightly being eroded. And the CMA, like any organisation, wants to feel relevant, and so we should also expect the CMA to be looking closely at media and political narratives and deciding are there any bandwagons, frankly, that it would like to jump on in terms of consumer enforcement. One other very important element is the expectation from government that actually this direct enforcement regime will drive complaints from competitors. So to date, the CMA has mainly received complaints from customers, but has received fewer complaints from competitors. If you contrast that to the competition law regime, where almost all complaints are driven by competitors or parties to agreements. So we all, we can see this happening where your internal commercial team saying, well, we're seeing our competitor doing this, why are you telling me I can't? The CMA is now expecting lots of companies to go in and basically sort of highlight to the CMA that their competitors are not fully complying with consumer law. And interesting that the government fully expected that, and that was one of the drivers of this new regime. And finally, we just wanted to flag, as we already mentioned, is that the CMA is also expecting referrals from within other parts of the CMA, but also from without the CMA. So we fully expect, for example, that Ofcom, FCA, etc., will potentially be referring consumer law issues to the CMA, particularly where they consider that the CMA has better powers to use there, or where there's otherwise like a concern that that the deterrence factor won't necessarily be driven in the right way if it's being done by the home regulator. So again, it's very unclear at the moment exactly where the CMA's cases are can come from, but the CMA is expecting a wider source of complaints than it's had in the past. So with that, I'm going to hand back over to Jenny, who's going to take us through some hints and tips.
Thanks, Chris. I think we can go straight to the next slide. So I think we are within our allotted time, so I can go through this slide slightly less at pace. So in terms of the sort of prize, I guess, for staying at the end is what do we think you need to be doing before April? So the first of those is to audit your current practices, so your consumer-facing terms and your marketing materials, particularly if those are devised on a global basis, where there has been a sort of risk-based approach developed to the attached to the development of those, and where previously the UK perhaps wasn't considered a high market, where now it should be. And we tend to, the way we've liked to think of this with existing clients is to sort of develop a traffic light compliance policy. So in terms of your current practices, auditing them and seeing which ones are sort of red and need to be addressed now, which ones are going to need to be addressed in the medium term, and then which of those you're already hopefully achieving compliance with. Because as I said, a lot of the rules have been restated, albeit with the additions we've taken you through today. The second of those is to be reviewing online user interfaces and systems. So to identify areas that will need to be reworked to comply with the new rules. So that would be where you need to implement additional reminders on the account of the subscription rules, or whether you need more functionality to show the prices inclusive of delivery fees, or change the prominence of information that you currently display to customers, be it online or I guess this could also apply to more hard copy traditional materials. But taking particularly IT systems, we tend to see that the lead times for those changes are not overnight. So whilst the subscription rules are actually something that we'll be looking at coming to force sort of early next year, it's certainly something you should be reviewing and understanding the process to update now, because early next year will be too late. The next is to add consumer law compliance to your annual roster of training. So typically we see competition being individually trained on competition annually and data protection annually. Would now expect consumer protection law to fall alongside those. And then the next thing you should sort of be aware of is that the ASA is updating its codes to link in with the DMCC. There was actually a consultation on that today. A consultation on that which closed today. So be aware, keep an eye on those changes and those guidance when it comes out. Just one aside to that, it will actually be interesting to see how the ASA go about enforcement in light of the enforcement regime for the CMA, and whether they'll become slightly more aggressive in terms of the unfair practices they look into to date. I should just flag, obviously we had a lot to cover. We were really keen not to take up more time than we said we would. So we have touched on a lot of topics at a high level. To the extent you'd like us to delve into any deeper of any of those, do let us know. It would be very helpful. We'd be more than happy, if helpful, to do workshops with particular clients to go into the key issues affecting them. In terms of questions, we did get one on whether this would apply on a B2B basis. The sort of overarching answer is no. The definition of consumer wouldn't include sort of sole traders or common law partnerships. It would include individuals acting wholly or mainly outside the course of trade. I think I can spot one more question, but I will follow up on that directly. In which case, I think all it leaves is thank you very much for joining us.
Yep, thanks, Jenny. Yep, so thank you very much for joining us. As Jenny says, if you do have any questions, do let us know. We just remains for me to say thank you very much for joining us today, and we hope you found the webinar helpful. Thank you very much. Goodbye.